for tonight, we're going to talk about litigation in general, but more specifically an eviction, because an eviction is a lawsuit. All right, an introduction to litigation and specifically evictions for your tenants. I'm going to assume that a lot of people, you're not going to watch it live, but you're coming to this video because you've got a late payment and you finally decided I've got to evict him. So I'm going to look up Ron's old video and see what do I need to know about an eviction after the fact. Okay, this is going to be afterwards. Again, quick introduction. Ronald, Rohde Law. We own a law firm. We're based here in Texas. We help commercial real estate investors do transactions. Please reach out to me and I can refer an attorney in your state, in your city. So to understand an eviction, you have to understand what governs the action. A lot of times your tenants will have disagreements or misunderstandings of the lease. And the lease is really important to be clear. It really, I think the goal of a lease agreement is just to provide clarity for both sides. What does it mean about the use of the space? Is the tenant allowed to do X? And do they have to pay Y? When do they have to pay it? What's the late fee? It's really a detailed agreement about what they can and can't do. So it's up to the landlord then to decide, when did the tenant violate? Did they comply? Did the landlord comply with their side of the lease? And if so, then you can move forward with sending a notice of violation and then maybe a default notice, and finally a notice of an eviction. So those are kind of the stages of escalation. They can all be merged into one time point. They can all be condensed and go at once, or they could occur over a period of time. So maybe you send a notice of violation, they have 5 days, they have 10 days to cure. And then after that, if they don't cure within 5 more days after that, then you set into default. But understanding what those policies are is critical ahead of time. And what I mean by that is figuring out how lenient do you want to be and what do you want to put in the lease about late payments. So for example, a very common exception or clause is that if a tenant is late paying rent no more than 2 times in a calendar year, a late fee, and they're not evicted for paying late. And again, they need to pay, I think, within 10 or 15 days. But the idea is, banking accidents happen. Maybe your accountant quits or something, and things fall through the cracks, and we get it. But as long as it's not more than once or twice a year, then you're okay. And obviously, you still have to pay within 10 days or 5 days of the written notice. But if you do that, you are in good standing with the lease. That's an example of a policy that is very fair. I think it's very reasonable and nice on both sides. But it's up to you to decide later on what happens if you accept a paper check and your department just didn't cash it. Is that the tenant? I mean, that's not the tenant's fault, but how do you go about instituting policies of enforcing that on your own side? Your property manager might quit. And how do you just decide what's fair and reasonable and putting that in the lease agreement? Second, tenant protection laws. It's not really protection. It's just what are the tenant laws? Because while commercial is much, much better than residential, residential leases are heavily governed by statute. In Texas, Chapter 92 is all about residential tenancies, what you can and can't do, what you have to provide, notices, that sort of thing, penalties. And it's pretty big. It's a big volume. And so there's a lot of detail about what happens in residential tenancies. Chapter 93 is on commercial tenancies. It's much shorter. I mean, I want to say it's like 1/10 of the length, maybe 1/15. It's just tiny because the amount of oversight that the state government imposes on commercial tenancies is a lot less. However, that's not to say it's zero in a commercial lease. So, for example, self-help is one of the things that they're very against, which is you as a landlord cannot go in and drag people out of your space. What they want to avoid is this confrontation. They don't want people evicting tenants and creating a violent encounter, right? Because if you show up to your tenant site without police or without this, it can create a conflict where somebody could get hurt. And that's what the law is designed to avoid. And in fact, you can get charged for criminal acts if you don't follow those laws. So again, another example, if you've locked out a tenant or you've done certain things, you have to provide a notice about how they can get the keys back, how they can pay a current amount and get back to zero, and then you have to give them the key. That's a statutory thing. You can't waive that. And no matter what happens, if you do a lockout, you have to comply with that, or else you're facing some statutory penalties. Finally, court procedures. Nobody likes to go through that, but it is important to understand what the process is, both in terms of time and cost. As they say, time is money, but the courts don't act quickly. And so it's really critical to understand how many days, or when we tell the lawyer we want to evict them, what has to happen and how many days have to happen, because I think you'll be unfortunately, displeased at how long it takes, even when you say go, we want to file this lawsuit. It's not just me, drafting a complaint and then submitting it the next day. There are notices. We have to send the notices. We have to wait until they're confirmed receipt. We have to let those periods expire. They may hire a lawyer. We may give them an extra day or two to respond. And those are all reasonable interpretations of the timeline, but you might be coming at me, 10 days later and be like, Ron, where's my eviction? Why isn't it eviction? Well, according to the lease, they have 5 days to do this. They have 2 days to do that. They've responded with this. So, what my piece of advice, because that court procedure does take a long time, and because it starts clocks, if you engage the lawyer, you can always pause eviction at any point in time. Even after you get a judgment, even if you get a writ, you can pause the eviction at any time, but you can't accelerate it just because you were negotiating with a tenant and then those negotiations broke down and you say, okay, Ron, now I want to evict him. I have to start from ground zero every single time. And so I always recommend start it early. You can always pause it, but it'll give you more leverage in your negotiations anyway. So that's kind of my advice is start the procedure, send the notices, comply with the lease, make the filing with the court. In Texas, it's filed with the Justice of the Peace. That is the sole court that has exclusive jurisdiction over evictions, both residential and commercial. You would file it in JP. You would get a hearing scheduled. You would pay the fees. That hearing usually takes about 2 weeks to get it scheduled. So you're losing time right there. But you have a hearing. You'll present evidence, you'll have a judgment. Either party can then immediately appeal that to county court, which is more of a real court. JP is a little bit of loosey-goosey, hearsay. There's no rules of evidence. It's just the Wild West. That's JP court. But you can appeal that to county court, and that's where, some rules come in and you actually get legal procedure. But understanding the costs, say eviction at a JP is $2,500. Just if you want some numbers. So that's what it costs to get it started to move forward. Maybe you could get some of that back if you get the tenant to move out voluntarily from the lawyer, but call it $2,500 and then just call about $5,000 for an appeal if they go and do that. Again, it depends on what the basis is, but if it's an argument of non-payment of rent and they still haven't paid rent, they're going to have to deposit that into the court registry as an appeal bond. They're going to have to pay the court fees. So if they don't have a good reason or an excuse as to why they didn't pay, or maybe they did pay to somebody else, okay, well, this is the process. So you got to send your notice in compliance with statutory law and the lease. You send your notice, you wait the prescribed number of days, and then you can file suit after you've done that notice to vacate. You'll have a hearing, which will be set, I said, call it maybe 2 weeks. The county appeal will take longer. So we're probably looking at closer to a month after, if you get that initial JP judgment and then they appeal that, you're probably looking at setting it 30 days after that judgment. And judgment and enforcement. So let's say you have a county court date, you guys go to court again, you have a little mini trial, and you get another judgment from county. At that point, then you can go to the sheriff and you apply for a writ of possession. That takes probably another week or two to schedule with the sheriff, but And then the sheriff will come out to your property. You should come with your handyman or maybe a locksmith. You cut the lock off or you change the locks and you get into the space. The sheriff is there to oversee a peaceful transition. You can take all of their stuff out of the space or you just change the locks on it. And then basically, if you have a good lease, you have a security interest, you can auction off their items, you can take an inventory, you can sell it, you can trash it. But you have possession of their personal property inside the space that they have left behind. And that's it. At that point, you can terminate the lease and you have regained this space after the sheriff has come and changed the locks. You can now re-tenant this out. So I don't know what that whole process is, but depending on when they were late, you're probably looking about 60 days with an appeal and about 30 to 45 days if you start it, on day one from when they miss rent, if there's just a JP, which is that kind of initial court. So 45 days or two months, those are the two choices for timeline. So what are my best strategies for avoiding litigation? I always tell my clients, I don't want to see you. I want to talk to you guys about buying new deals and making lots of money. I don't want to see you here for litigation because unfortunately, litigation is really just a negative net expected value for both parties. Nobody is going to win except for the lawyers, right? We get paid. But it's really critical that I think you come up with policies. And if you're going to be owning and managing these properties, you're going to have situations where a tenant is short on month or he does something that violates the lease, like parking too many cars or dumping oil. And my point of that is you're going to have people that toe the line, but what should your policy be if you don't want to just full-blown evict them? And that's where mandatory penalties can come in. That's where in the lease you can specify, okay, if you do X, the penalty is Y. If you do Z, then the penalty is A. Things like that will help kind of avoid uncertainty. It does kind of give them a license to do it if they just want to pay the toll. It becomes a toll. It says, well, if I'm not going to get evicted, then I'm just going to violate the lease and I just pay the toll and no harm, no foul. Which is not necessarily good either. But think about what are the types of issues that will come up, and you can incorporate those into future leases. Effective property management. I'm going down to this bullet. Open communication solves 90% of the problems. I won't go much higher than that, but maybe 85%. But really, a lot of times there's a miscommunication between the tenants about what they can and cannot do, about expectations of rent payment, and then especially unequal treatment among the tenants. So one thing that I would probably have you guys assume is that all of the tenants talk to each other and they all like each other more than they like you, the landlord. I'm not going to say they're going to like unionize and they're not going to all band together, but I almost guarantee they do talk and they will show each other documents and say, hey, he gave me X or he only penalized me Y. Because if you treat some tenants unequally, the word will get around and it will undermine your credibility when you threaten something if you didn't do it for somebody else. So making sure that your property manager conveys the same standards and the same rules is really critical to kind of have that like unity of message. Regular inspections. That's another thing. If let's say there's a rule about no indoor gas storage, but if you're not regularly in the units, and again, this is maybe quarterly, maybe this is every 6 months. I just mean don't go 9 months without looking inside the unit. If they're storing gasoline or some type of other combustible chemical inside and not in a flammables cabinet, or they didn't provide MSDS forms, those are material safety data sheets, you're not going to know. And that's the issue is they think they're just going to get away with it until they get caught. But if they never get caught, how are you going to enforce it? And I will say that storage of unlawful or not non-permitted chemicals is kind of a big deal. You as a landlord don't want that inside the building. Or if they are a paint booth or they are a body shop, then you need to know what's in there, that you need to know that they're properly stored and not just being dumped down the drain. But again, regular inspections is just good all around, and they know that they're not going to get away with stuff if they see that the property manager is walking through units. So you can really avoid having to evict a bad actor just by having regular inspections, so they know they're not going to try to get away with anything. Legal guidance, obviously, having a good commercial real estate attorney to ensure that your leases are up to date and reflect your goals, the unique attributes of your property. That is the way to have very clear communication with your tenant. Again, I think the time to find a litigation or eviction attorney is before you need the eviction. Make those contacts ahead of time. Don't try to call three or four of them all in one day and then try to interview three or four of them in 24 hours and make a decision the next day. I would call them ahead of time and just tell them who you are. And, we may have these issues and just wanted to see what your workload was and, see if it'd be a good fit for working together. That's it. I mean, it's not a lot of effort, but it puts some attorneys, it gives them an opportunity to be responsive. It gives you an idea about their billing or their fee structure. And, it's just that introduction, because I guarantee you're going to email a lot of people and they just won't even email back. You may call people and they won't even call you back. So that's not a great candidate if you're in an emergency and you have a critical need for counsel. Finally, mediation and negotiation. I don't know that this is as applicable for just flex space stuff because these are smaller tenants. You're not necessarily in love to keep them, but I do have it on my slide because for most of my other tenants, if you have, or most of my other clients, if you have larger properties like a single tenant industrial, which is pretty common, you probably want to try to work it out. And these are maybe for more than non-payment of rent disputes. These could be for lease violations, so alleged breaches, storage, or hey, you're not allowed to manufacture, or you're not allowed to throw your waste here, and it's a big problem. But you want to keep the tenant because they're paying you $22,000 a month, and no, neither side wants to go through the hassle of finding new space or finding new tenants. And so sometimes my point is that mediation can sometimes produce agreeable cooperative outcomes that I, as a party, or I, as the lawyer, I did not think that was possible. I've gone into mediations with very, very low expectations, preparing to waste my time. And at the end of the day, we ended up with a settlement that both sides accepted. They weren't happy about it, but it was acceptable and preferable to continuing in litigation. So it kind of blew my mind. But these mediators, some of them are really good at figuring things out, that what the other side, what each party wants. All right. Thanks, guys. Have a good evening.